Good evening. This is Rahul Reddy, live here from Houston, Texas. Along with me is my business partner, Reddy Neumann. Today we're going to discuss about the Congress has shelved immigration reform completely right now. What can our administration do right now? Also, we're going to discuss about consulate appointment updates. We're going to discuss about the H1B cap announced now, what actions need to be taken if you are anticipating to be participating in the H1B lottery. Emily, we know that immigration reform was supposed to happen, didn't happen, will never happen. We don't know how the things are. Immigration reform has been there on the agenda since the time of Clinton era. That is somewhere in 1993, 94, from that time to right now. No major immigration legislation has ever been passed except in the time of Ronald Reagan. We do not expect right now, with the way the things are in the Congress, that any major immigration reform is going to be passed. Do you have any hopes on that, Emily?
No, I've pretty much lost all hope.
There are still hopes that maybe the per country limit will be taken off to an extent. We will have to see if that can happen in this session, in this year of 2022, hopefully so. But while this is pending, though, what can the administration do? They tried to increase the green card numbers, that didn't happen. They tried to increase a lot of different things, didn't happen. Can they do it unilaterally without going to the Congress, which we, in the rest of the world, we call it as Parliament?
No, I would say Trump gave us a really good view of that the president can do a lot with immigration to mess it up, but also to improve it. And so there are actions that Biden can take in order to improve immigration, in order to change the interpretation of the law, so that only Congress can change the law, but how it's interpreted depends on the particular administration. So what kinds of things do you think that would be beneficial?
First thing I want to suggest to the administration, Emily, is that when you are doing when you're making any administrative changes, though, when you're issuing an executive orders, when you're interpreting the law differently than what it was being done, he should not be doing it at the end, though. He should not wait for the second term. He should not wait for the fourth year of his power, though. He should try to do very early. What happened to Obama? He waited until the second term, and the 8th year he started passing these executive orders because he decided by that time nothing is going to happen. That should have been done initially itself in the first 2 years of the administration came into power. Just like the way he passed the healthcare reform in the first 2 years, he couldn't pass the immigration reform. He should have realized it and he should have passed it. Of course, we know Trump is anti-immigrant. He never liked any immigration. He never liked anything immigrants do. But Biden administration is definitely a favorable person to immigration. He's much better than compared to the Trump administration. So he has a good intention towards immigration. So he should start acting right now, because he has given 1 year chance for the Congress. They didn't do anything, and it's not expected to do anything. They don't have anything in the agenda to do anything on the immigration reform side. So he should try to unilaterally act by himself. The number one suggestion that I would do is that he should stop counting the family members for the employment-based immigration. As you know, Emily, there are only 140,000 employment-based immigration green cards every year. Out of the million or so green cards, only 14% are going to the employment-based. In the INA provision, the way the Congress passed, they left it open for interpretation for the administration to either count or not count the family members. Now, if we stop counting the family members, though, the backlog of the immigration, especially the employment immigration, will come down significantly. I mean, within 3-4 years, we may see the entire backlog disappear, though. At least for a while, it may be like that for at least 5 to 7 years. So within 2-3 years, it should disappear, and maybe in a couple of years, it may come back. But for sure, most of the people who have been waiting in there don't have to wait for that long, Emily. Do you have any other suggestions, Emily?
We definitely need the premium processing that Congress approved 2 years ago now to stop USCIS from going broke. They passed that emergency stopgap bill, and we still don't have the premium processing from that. They need to implement that as well. That would provide, obviously we don't want people to have to pay a lot of money to get standard service. It's not the best thing we could ask for, but it's something that they could do that's already authorized and they've been dragging their feet on.
USCIS director has come, the current director has come with an agenda to simplify the process, to expedite the things in general though. However, when implementing the things though, it doesn't look like they're doing it as fast as possible though. They have increased the speed of the employment-based immigration. They have given some indications with regards to EB3 to EB2, upgrading a newer process, filing a 485J supplement. They have also removed the biometrics requirement for the H4 extension. They have given automatic 180 days extension if they have the I-94, but a lot more need to be done though. If they don't adjudicate the 485 applications that are pending right now, they will be pending for a long period of time, because technically they cannot issue them because the priority date may not be current for these people going forward. We have extra 140,000 green cards available, 280,000 green cards. If they don't give the green cards to these people this year, you will have to adjudicate their EADs and advanced paroles for the next decade. And there is no filing fees for the EAD and advanced parole. If these people just give them the green card right now, that numbers will be used. They don't have to give the EADs and advanced paroles for these people forever, for the 10 years that coming forward. Those things can be done. I think so. They have to have automatic issuance of the EAD. I mean, based on the 485 receipt, that should be allowed to work in United States instead of getting an EAD approved. That can be done. That's a simpler process that can be done. They should stop issuing medical RFPs. I mean, if they can always issue the green card, and they can always request the medical afterwards. Who is not going to submit it? You can always revoke the green card at a later date. As you said, premium processing definitely is a step forward though, but I think so there is a lot of processing things that USCIS can improve. We can go back to the previous, before Trump era, where 485s for the employment-based were not required to be interviewed at all. Only 2 to 3% of the cases were getting interviewed at that point of time. Right now, we have 25% of the cases that are getting interviewed, though. So if they take the interview process out, that will save a lot of energy in the 485, adjudication will be speeded up. Any other things, Emily?
No, I think those are all great suggestions. Hopefully, we'll see some of these things moving forward. We do have a letter writing campaign that we would like you to take part in order to urge the executive branch, the president, to have his administration implement some of these changes, particularly the not counting the family members. That would be a huge benefit to employment-based.
We have put an article link at the bottom of this video where you can write a letter to the Ombudsman of Department of Homeland Security and also USCIS Director to not count the family members, and in that way they can reduce the amount of time that people have to wait for getting the green card. So please use this letter as a draft, make any necessary changes. You can even send this letter to your congressman to absolutely just change the wordings a little bit. You can send it to the congressman. You can send it to the senator. You can send it to the ombudsman. You can send it to the USCIS director. The links were being provided there. The draft of the letter has been provided there. What you need to write, and please fill in the blanks that have been given. These blanks are where you will have to describe over your personal detail. Please write this letter. If you recall that we started the campaigning of not wasting the green card about 9-10 months ago. Since the time, USCIS definitely has improved. The adjudication of the employment-based immigration in the last fourth quarter, they have done more than what they have done in the first 3 quarters though. We still request, if you have not written to the congressman to increase the pace of adjudication of the employment-based, that link is still there. You need to write so that we get all these 280,000 green cards utilized this year, and hopefully so. They are not going to count the family members. In that way, the number of green cards will go up from 140,000 to approximately 300,000 green for the employment-based immigration. The link is provided. Please use that and write those letters. Emily, on the consulate updates, what are you noticing there in the appointments? As you know that if anybody has ever got their visa in US consulates in India, they are all eligible for the drop box, even if it's a change of status, even if their ex visa has expired long 10 years ago, they can still go for the drop box. And this provision is only until December 31st of 2021. What do you see any improvements? Do you see any appointments? How are things going in the consulate?
With the Dropbox, the difficulty is you still need another appointment for the Dropbox, and those are really hit or miss. I have some people that were able to get them in February, other people saying they're not available until August. It just depends on when you happen to log in, how many times you hit refresh. There's just not enough appointments available for even the Dropbox process.
It has been much better compared to what it was in November and December, Emily, compared to when I see in the January though. As you said, if the people keep on refreshing, they will get it. Some people are telling Thursday is a better day. Some people are telling Friday is a better day. But you may have to do it many times, log in and try to refresh the things to see if you get an appointment dates. Yes, they are available, but you have to keep on refreshing. That's the only thing that is there. The appointments have become, compared to much better than last year. That's what I see. Going forward, because there's a lot of rush that is going to the consulate right now. People have been waiting for 2 years because of the COVID. They have not traveled. There are travel restrictions in India. There were travel restrictions in USA. The consulates were closed completely though. So there's a lot of rush that is going to get the stamping right now. With the Dropbox and the efficiency of the Dropbox getting improved and the number of people going to Dropbox more have increased more though, I'm expecting that there will be a better situation in about 2 to 3 months. That's my expectation in the visa appointments in the Dropbox. Anything else, Emily?
All right. Also this week or last week, USCIS finally announced when the H-1B electronic filing window will be for this year's CAP. So for those that are subject to the CAP and have not been counted previously with an H-1B before, your employer has to submit that registration between March 1st and March 18th through the My USCIS account. If they're working with an attorney, the attorney starts that process, hands it off to the employer with a passcode, and then they send it back to the attorney's office to complete the process. All of that has to happen between March 1st and March 18th. So if you are needing your employer to submit that registration, number one, make sure they're aware of the process, make sure they're aware when it has to happen, and that you are getting those things taken care of now. If the employer's never done it before, they need to create a My USCIS account, and then you need to make sure that they have the correct documents for you to be able to get that submitted. Usually what we ask for is a copy of your passport and a copy of your degree certificate so that we can verify which CAP you fall under, whether you can qualify for the master's CAP or not. And we need the passport for the biographic data information, which is what we enter into the My USCIS system for the registration. We also like to review your other visa documents, especially if you're on OPT, so that we can see when your OPT is ending. Because if you are selected and you need the CAP gap, we have to make sure that we file the H-1B petition before your OPT expires, even if it's expiring before June 30th. So all of that stuff, we have 1 month to go from today. So now is the time to be prepared and make sure your employer is prepared and getting all the information to your attorney.
We strongly want people to not go to these fake companies which doesn't have job and file in the lottery, even though you will think that you are lucky to get in the lottery system to this company. We see long-term problems with these companies though, because when these companies, they try to do illegal activities, they will get caught in one day or another. Once they get caught though, you will be suffering at that point of time. So you may gain temporarily, but it's going to be a loss. We strongly recommend to stay away from these companies who don't have jobs, but they are willing to file through the lottery system. We strongly recommend you stay away from those things. Time and time again, we see so many people that have worked with these companies previously though. Their H-1B gets revoked at a later date. So for example, you go to a fraudulent company, they file a H-1B, they might have filed for a lot of other people, and they get the H-1B approval. And why these government approves these people, we don't know. When they approve these H-1Bs, you move on from this company A, which is a fraudulent company, to company B, which is a very nice company, and from company B to company C, which is also a very nice company. However, though, at a later date, the USCIS can revoke company C's H-1B, even though company C has not done anything wrong. The reason that what they give is that you've been wrongly counted toward the H-1B number with company A because they have done fraudulent activity. This happens every week. We get so many consultations from people who have worked with these companies and we've been defrauded by these companies, and they eventually cry at a later date. We strongly recommend that you stay away from this company. We have been warning it many times. Please stay away from these companies. Anything else before we go to questions?
I think we can go to questions. Let's start with Uma, who wants to know, is EB1C only for L1A, or can an H1B holder apply under EB1C if they transferred in a managerial capacity and all the other criteria are met? Yes, that is possible. You don't have to be only in L1A to qualify for EB1C. Just requires that your foreign position was managerial or executive, the U.S. position that's being offered is managerial or executive, and the right qualifying relationship exists between the two companies. Sometimes it's helpful to try for an L1A first, especially if it's the first time the company is doing that, because then once that's approved, you have not better chance of the EB1C being approved, but it's more likely that it will be approved since they've already approved the L1A, but not required.
California Service Center H1B extension processing time is 8.5. Other service centers are 4 months. Why? Well, that's the question that you need to ask the USCIS. We definitely are aware of it, that the California Center is really backlogged. In H1s, they're really backlogged. In H4s, they're really backlogged in the H4 Eads too. So that definitely is a discrimination, but there's not much we can do about it.
Kamal asks, how much time after filing an H4 and EAD renewal can we submit an expedite request? It's been 100 days. The H1 is already approved in premium. So there's no set time frame for it. You don't have to wait a certain number of days before you do an expedite request if you meet the criteria. At the same time, I think what USCIS is looking for is that your EAD, your current EAD, is expiring in 30 days or less. So if you filed super early, you've waited 100 days, and you still have 5 months before your EAD expires, they're not going to accept an expedite for that. But if you filed and now your EAD is expiring in the next 30 days, and you meet one of the expedite criteria, then you may have that option.
Arun Chakrabarti is asking this question. While waiting for the 485 EAD that was filed in October 2020, can we now apply for a H4 EAD? Is that going to cause any problem? No, absolutely not. Even though your 485 EAD is pending, you can still file the H4 EAD. Srinivas Dingari has his question. His priority date is September 2012 in EB3. What are the chances of getting the GC this year? Do you want to initiate another EB2? That it may be worth, if you have not downgraded and this is the only thing, you may want to initiate the EB2 also to see if by any chance EB3 stays there, and EB2 is current right now. So you may want to look into, you may want to consider that option though, because if you file another PERM labor certification, you're not doing anything harm to your existing application. If the EB3 moves forward, then you're in a good position. But if it does not, then if it does not, then you can always use the EB2 labor certification. Emily, I need some discussion on one of the topic Kishore is asking it. EB1C I-140 processing time shows 11 months to 51.5 months. Is it really taking 51 months for an I-140? You said the principle that if the lower end, that means 11 months, means more than 50% of the cases are approved within 11 months.
50%, not more than.
So Kishore, more than 50% of the cases, according to USCIS, get approved at the lower end, which is actually 11%. Now, 51 months is it 90%?
93%, I believe.
So 93% of the cases that were being applied get approved by 51 months. Only 7% of them things don't get approved. So 50% get approved in 11 months, and rest of the 43% will get approved in the 51 months. Have we seen cases which takes 3 years also in the EB1C category? Yes, we have seen it. Unfortunately, for the EB1C, there is no premium processing. You'll have to just wait. There's not much that can be done on it.
A question on the downgrade. So we filed an EB2 to EB3 I-140 downgrade in September 21 and now filed for premium processing with Nebraska Service Center. What are the chances that premium processing will be accepted? I feel like they've gotten better at this, and I'd say probably 75%, especially since it's been a few months since you filed, as well as it was not filed during the October 2020 madness. So it does have a decent chance of getting accepted the first time around.
Sen Abhijit has a question. I got my green card. My wife got an RFE, but priority date got retrogressed. Do you suggest to sit quiet or file a family-based immigration though? If she is maintaining the non-immigrant status though, Mr. Sen, I would strongly recommend that you file the 485 under family-based though. The reason is that if you're not going to harm anything, the existing application, you're going to file one more application. Since the family-based, you're going to file under the family-based 2A. It's mostly current at all times though, so you can use that and get the green card. I would definitely file her under the family-based immigration if I were you.
Srinivas has, him and his wife are both on H1B, but in her case, her extension is pending and her I-94 recently expired, and he wants to know if he can still file the 485 in that situation when their date becomes current. Yes, that is possible, as long as the I-94 has not expired more than 180 days before the time you file the 485. Now, if it's expired less than 180 days from the time you filed the 485, even if that extension were to get denied, she's still fine. She can still stay in the US based on the pending adjustment of status. But if that I-94 expired more than 180 days before you file the 485, you can still file the 485, but if her H1 extension later gets denied, her 485 will also be denied, because that denial of the H1 goes back to before when her I-94 expires. So there's a little risk if it's pending more than 6 months after the I-94 expires at the time you file the 485.
Jayshankar has this question. What is the process of upgrading EB2 as my AOS is in EB2? We want you to watch the last week video which exclusively covered on that topic, mostly at least 50 minutes we covered on it. All your employer has to do right now is to file something called 485J supplement. They can send it to a particular address in California that was being provided last week, the previous week, Friday. That's about 10 days ago. They created that address and they have provided it. That's an easy way of doing the EB2 upgrade.
Manoj wants to know what happened to the H4 EAD lawsuit. Why aren't we pressing lawmakers about the H4 EAD delays, and what are our efforts? So absolutely, please continue to reach out to your congressman and senator's office about these delays, because they are continuing. The 180-day auto extension doesn't help everybody. The suspension of the biometrics is only temporary, and it's not causing processing times to be that much improved yet. Push them to implement the premium processing. But what are our efforts? We still have a class action lawsuit ongoing, and that is in process. You know, the settlement negotiations, trying to get USCIS to agree to certain timeframes for that. So yes, that lawsuit is still ongoing, and we hope to get a positive result from that. We just can't say when, because it's all depends on the judge.
Radha from Facebook has this question. Planning for India trip, 485 has been applied in October 2020 in EB3, prior date is March 2012. Biometrics done, medicals interfiles, sending interfile request for the EB2 with 485J. What else should take care while we are away? Well, you have done everything you possibly can, so nothing can be done. So have a nice trip to India. That's all I can tell. You have done the medicals interfiling, you have done the interfiling of the 485J. That's good steps that you have taken. It's not more than what you have already done. You can't do anything more than that.
Nikila has an H1B amendment pending and is planning to start a new client location that would require another amendment to be filed, and wants to know, can I just use my 485 EAD while the first amendment is pending? Yes, you can do that. You don't have to continue to maintain your H-1B status once your 485 is pending and you have the EAD. I'm assuming your I-140 is approved. That makes it a little safer to do that. Once you use that EAD, though, you're no longer in H-1B status. So you would probably want to discuss with your company about withdrawing the pending amendment as well, since you don't need that anymore. Definitely things to consider about switching to EAD from H-1B. We have an article on rnlawgroup.com about that goes through the pros and cons and what the process is. I think we have a video as well on that topic.
Litendra Chowdhury, I'm currently on H-1B. I want to move to H4. And a few years later, can I come back on H-1B and utilize the rest of the 6 years? That means that if you have used 4 years, can you use the rest of the 2 years? Yes, absolutely, you can do so. No problem. You can move to H4 and 4 years, 5 years down the line, you can come back on the H-1B. Absolutely, you can use the rest of the 6 years though. If your I-140 is approved, then you can use, there is no 6-year limit for you if the I-140 is approved. And a lot of people have confusion that when they move to H4, when they come back, they need to have a H-1B numbers available. No, you don't need it. If you have an I-140, you definitely don't have to. If you have used a part of the H-1B of the 6 years, you can use the rest of the 6 years at any point of time. There is no time limit, there is no 2 years, there is no 3 year. You can always come back after 7, 10 years and then still use the rest of the period that is left over in the 6 years of the H-1B.
Jagadish got his EAD and is planning to file an I485 Supplement J when he joins a new employer. He also wants to do a part-time job of math tutoring and wants to know, does he need to do a 485J for that as well? No, you don't. So you are allowed, when you're using the EAD, you can work for multiple employers. You just need one that supports the pending 485 through the Supplement J process. So just the main employer where the job is similar to the position you were sponsored for, that's full-time permanent employment, that's the one you submit the Supplement J for, but you can work any other job on the side.
Bhavani has this question, can L2 EADs or H4 EADs do business? Absolutely they can. Any legal business they can do it. Absolutely they can. No problem with it. H4 EADs and L2 EADs, there is no restriction on what type of business they can do. They can do anything they want to legally.
Ram has an EB2 priority date in 2010, filed the 485 in 2020, got interviewed, still no approval. The process seems so random. People are getting approvals who applied in October 2021, a year after. Is there anything legally we can do? We are seeing the same in our office. It's very, very random. Partly depends on service center, but it's just so hit or miss. But is there anything legally you can do? We generally seek court assistance when USCIS is acting unreasonably, including delaying cases unreasonably. The difficulty with seeking the court assistance in this type of case is they always come back and argue that adjustment of status as a process is discretionary. There's no set time limit for USCIS to act on it. They can do it whenever they please, so a court is not going to force them to do it within a particular amount of time. So for a court to actually see that it's unreasonable, it's not unreasonable even though other people who filed after you are getting approved faster, it would be unreasonable after several years of the final action date being current and you're still pending. And we haven't seen a lot of people getting to that point yet. That's more where litigation can help.
EB2 to EB3 downgrade, will it set back the time for the 180 days though? Sorry, EB2 upgrade actually. The person has upgraded from EB3 to EB2 upgrade. Now there are conflicting information with regards to the 485J instructions and the recent instructions by the USCIS. At this point of time, because of the recent development of what they have put it on their website, I will take the conservative approach that yes, it resets the 180 days if you are doing interfile. This is a new interpretation that they have come up with. We don't know how it will be enforced because there's no process of withdrawing the 485J supplement, but we are taking the conservative approach that that you have to stick with the company. If you're already working for the company, you have to stick with the company for 180 days after you file the 485J supplement. What will happen if the person never worked for the company? They can still file the 485J supplement to upgrade to EB2, Emily.
Mm-hmm. Yeah.
When in that case, also 180 days is applicable.
Question.
Yeah, it's good.
They kind of made that rule up. I don't see where that.
Yeah, it could be. It could. If any green card is denied because of that, though, I mean, if it is, it can definitely be challenged in the court, because we don't see any reason why they come up with a 180-day rule in this one, though. But at this point of time, we are taking the conservative approach of telling people that you have to stick with the company for 180 days after you upgrade to EB2.
Mita says, why is the DOL taking so long for prevailing wage determinations? Is the issue being escalated? You're right, they're terrible. There are some reasons that are reasonable behind it. If you recall, during the Trump years, he tried to change the prevailing wage levels and all of the actual wage calculations. And so a lot of people, before that rule was to take effect, filed prevailing wages to try to beat the deadline for the rule change. That caused some additional work for the DOL. So they received a ton more prevailing wages than normal, which slowed everything down. On top of that, later, the prevailing wages were changed back due to court litigation. So the DOL had to go back and reissue prevailing wages for all the prevailing wages that they had issued under the new rule. That set them back even further. So those are the reasons behind it. Also, it's not a fee that you file to get the process done, so they don't have additional resources or additional funding in order to do the additional work, so you're limited with resources as well.
Ravi is announcing he got his green card. Congrats, that's very good. But he's also informing that he filed the 485 application in June of 2021, and he got his green card approved on January 31st of 2022. So that's approximately 7 months. We are seeing a lot of these things. They're not getting EADs just like you. They're not getting advanced parole. The problem is mostly with the cases that have been filed between October of 2020 and December of 2020. They are stuck though. But the cases that we have been filing in June, July, August, some of the cases even in September, and some cases even in October of 2021, we got their green cards approved. However, the ones in the October, November, and December of 2020 are still pending for a good number of people. Any insight, Emily, why the cases that are filed later are getting approved and the ones that got stuck in the Texas Service Center in October, November, December are still stuck there?
Yeah, I don't know why they do that, but they do always do that. Anytime there's a big backlog, it's the exact same thing with H4s and H4 EADs. Those that filed a year ago are still pending, and people that filed 6 months ago are getting approvals. They work at it from both ends, not first in, first out, which doesn't seem very fair.
Yeah, it happens though. But yeah, we noticed a lot of those green cards that we filed in September, October also getting approved too, in 2021.
Amit wants to know, can we go for H-1B visa stamping in Canada if the individual is an Indian citizen? So prior to COVID, yes, that was an option. Both Canada and Mexico would accept third country nationals. But during COVID, all the consulates are operating on such low levels that they're really only providing services to their own citizens right now. So you cannot get an appointment for Canada or Mexico if you're not a Canadian or Mexican citizen.
Kamalesh has this question, EB1C, is there any benefit of putting the priority date from other category? Absolutely yes. You may be thinking right now the priority date is current in EB1C though, but you never know. It may not last for long though, as we already know that there are extra amount of green cards that are available for this year, and there will be some next year though, but we don't know it's going to be there forever. So definitely, if you have a priority date, port it, please. Don't just look into the EB1 priority dates and then think that it's going to be current forever. No, don't. Just port the priority date if you can.
Surya wants to know, does refiling an EB2 reset the 180-day AC21 portability of the previously filed EB3 485? No, it doesn't, but practically it's the same thing. If you were to, you have your EB3 485 pending for over 180 days, now you're filing a second 485 for EB2 and it's pending less than 180 days. You do have portability of the EB3, but you would risk denial of your EB2 by porting before the new 180-day clock set. So you'd basically be stuck in EB3 potentially.
What can we submit if we don't have the non-availability certificate and birth certificate, SH Reddy from YouTube? You can submit 2 affidavits. If you can go to rnlawgroup.com and search birth certificate, the affidavit format is there. And also, I would request you to prepare the alternative documents. Don't submit it, like for example, hospital record, Aadhaar card, PAN card, ration card, election card, anything that shows your date of birth, school leaving certificate, 10th class memo, all these things, don't submit it. I will just submit with the 2 affidavits. And if they issue an RFE, then you can submit with the rest of the documents that I told you right now.
Tuino, has USCIS sent my wife's H4 Ead card to my old address, even though I changed the address using the online tool at USCIS. Yeah, is there any hope for USCIS issuing a new card since it was their mistake? We do not have good success with that. It is such a pain. Basically, they claim that they can't send you the card until the post office returns your old card as undeliverable. So if that mail was picked up by the new people that are living there and never returned, your card is lost, and USCIS doesn't consider that to be their mistake, even though they're the ones that sent it to the wrong address. So you should submit a request for assistance through the USCIS Ombudsman Office. They may be able to help. As a backup plan, you may want to also file a second EAD application because the Ombudsman might take just as long as a new filing. So it might cost you more money, but it might be faster to just file it again, unfortunately.
Should we file the medicals along with the, along with the 485J supplement? I strongly recommend no, don't submit it. Here is the reason. I put a small video, it's about 2-minute video, guys. It's a very funny video. I want you to watch this video. I just put it there. These people, the government employees are trained only to do one thing. There is an address. We are supposed to send the 485J with the supporting documents. And there is a persons there. All they are looking is the 485J supplement, I-140 approval, 485 receipt notice, and the supporting documents for the 485J supplement. That's all they are looking for. Now, once they see the medical, they don't know what to do with that medical. They don't understand where does this come from, and they'll get confused with that. So I would rather want to submit medicals separately rather than include in the 485J supplement. It's a very funny video. I put it there. Please watch it though. You'll enjoy it when you see it. That's exactly how the government employees work. If you watch the video, it's just a 2-minute funny video. It's there on the Facebook. I just put it. Watch it. And that's the reason I do not want to include the medicals along with the 485J supplement.
Speaking of funny videos, Tintin has a funny question for today. He says, per your words, I bought champagne and stored it in the refrigerator after submitting my medical RFE last year. Still waiting for the green card to open it.
Uh-oh.
Champagne is expiring in 2 months. How do I renew it? Yeah, that's immigration these days. Everything's expiring. Nobody's getting anything done. Everything's a mess.
Yeah, definitely the people who got medical RFEs, a good number of them have got the green cards. So yes, unfortunately, I hope your champagne doesn't expire and you get the green card before, but let's see what goes on.
M. Savala says, my daughter got her GCEAD through CESPA, Child Status Protection Act. She's currently on F1. Should she remain on F1 until her green card is approved or start using her GCEAD for her master's and her jobs? So assuming that you mean that her age has been officially locked under the Child Status Protection Act, then it's really, and that would be because your I-140 has been approved and your final action date is become current. And if you take into account the number of days the I-140 was pending, it reduced her age to below 21. So your I-140 is approved. In many cases, not much goes wrong with the 485 process after that. So if her age is locked, she could use her green card EAD. She doesn't need the F1 anymore as the backup plan.
Nirmal has this question. Can I use the NIE? NIE is the non-immigrant
the national interest
exemption. Can I use that for filing NIW, though, a national interest waiver? No, that is not the sole basis for filing the national interest waiver. You must have other qualifications, though. You can't use that, definitely not.
The Lux says, can we file the H4 EAD while the applicant is outside the U.S.? Unfortunately, no. You have to be physically in the U.S. in H4 status to file the I-765 application. Once it's filed, you can travel outside the U.S. And come back without impacting the pending application. But on the day of filing, you have to be in the U.S. in H4 status.
Naveen Vimasani has this question. His downgrade I-140 is still pending. Can he do the interfiling of the EB2? We do not advise that. Is it illegal? No, it's not illegal. Definitely you can do it though. But we feel that you still need to get your I-140 approved. I would strongly recommend to do the premium processing, get the I-140 approved. Now, the premium processing is working for most of the people, but not for some people. For most of the people, when we file first time, the premium processing is accepted. Sometimes we have done like 10, 15 times, but some of the people after 15 times, it's still, they're not accepting it though. And Emily, what is this, the way that the processing time, especially the Texas Service Center, is that they keep on moving back. I mean, they never are crossing the October of 2020. Mm-hmm. They used to be 6 months. Now, when they moved to October, then they said it's 8 months. When they moved a little bit further, they kept on moving. Now, what's going to happen with the processing times of the Texas Service Center for the I-140s that are regular processing time, Emily?
Yeah, that's the hard thing because you can't follow up until it's outside normal processing. So they just keep saying everything's normal, and then you don't get to follow up. So really premium processing tends to be the only option for those cases where premium is available. Other than that, yeah, it's everything's just a mess with processing times.
Nitin has filed downgrade EB3 to EB2, and he did the new I485 and EB2. He is current in EB2 right now. Should I interfile as per the USCIS alert though? At this point of time, Nitin, we are recommending that you do not interfile at this point of time. Now, we may change our idea in the coming weeks though. What if they keep on pulling out all these downgrade upgrade applications and adjudicating those applications left and right? Then definitely we may recommend you at that point of time, because who knows, I mean, things may move back and forth. So we do not recommend doing interfiling because you already have both applications at this time. Maybe we'll change our opinion later on.
Sai Ram says, can I switch to employer B immediately after getting the I-140 approval? Is there any chance that employer A might revoke it? Well, technically an employer cannot revoke an I-140, but they can withdraw it at any time. If they withdraw it less than 180 days after the approval, that withdrawal becomes a revocation by USCIS. And when that's revoked, you still get to keep the priority date as long as it's not revoked for fraud or misrepresentation, but you cannot use that I-140 approval to file H-1B extensions beyond the 6-year limit or to file H4 EADs for your spouse. So definitely think carefully about that before you decide to make the switch early.
Mohan Singh, does USCIS prioritize between the 485 with priority date current and with priority date not current? Yes, they do prioritize, definitely. If the priority date is not current, they should not approve the green card though, definitely. Only for those people whose priority date is current, they will adjudicate the 485 applications. There are some cases they get interviews, even though the priority date is not current, they will be interviewed. That's normal, but normally they will not approve if the priority date is not current.
Vijay says, after visa revalidation on a return trip from Cancun, we got the I-94 cut short due to passport validity. And he wants to know, after the passport's renewed, what should we do to get our I-94 till 2025? You have a couple of options. Once, assuming that you're doing this before this shortened I-94 expires, once you have the passport renewed, you could take another trip, and when you return from that trip, you would get the full period of your I-94. Another option would be to file extensions based on the shortened I-94, and then you would get the additional time. But usually travel is the best way to cure that.
Parrot from Facebook has this question. While the PERM process is pending, can I travel outside the country? Will it cause any problem? Assuming that you're traveling on H1B or H4 or L1 or L2, you do not have any problem in going outside the country and coming back. Next question that comes up from Michael is, on the PERM itself, is if I move to a different status, will it cause any problem for my PERM application? The PERM application is for the future job, not your current job though. As long as your future job, they are telling that the future job is still there, you do not have any problem in you moving to a different state while the PERM is in process.
Deepak says, what could be the reasons that June, July, and August visa appointments are not available, whereas the rest of the months they are available? That is a good question. Usually, the Department of State puts out a little alert saying, hey, summer is when everyone travels, so consulates tend to be very busy during the summer months and it's hard to get an appointment, but it sounds like they're not even available to begin with. Also in the summer, that's when you have a lot of F1 students who have applied and are trying to get their visas to go for the fall to begin, and also H1Bs. Summer is very busy. Once those that get selected in the lottery and get their petition approved, they can apply for the visa 90 days before October 1st. I don't know why they would be closing those appointments off in advance. Seems a little bit odd, not sure.
Rao has this question. My spouse H4 alien number and the 485 receipt alien number is different. Is that okay? Perfectly okay. Not a problem at all.
Michelle wants to know, is it okay to move to a different state while my PERM... you got that one already? Yeah. All right, let's see. Chetan, do we have any hope of premium processing implementation for the H4 EAD to be implemented soon? It's still stuck at OMB. Yes, I checked it yesterday and it's still stuck at OMB. It's been there since December. OMB does not have a deadline to do that review, and obviously it took the administration a very long time just to submit it to OMB. So unfortunately, we were hoping to see it soon. That doesn't seem to be the case.
Any improvements in the Texas Service Center 485 application processing time? Another person is asking question. I filed 485 application in October of 2020. I still did not get an EAD in advance parole. Well, that answers the question for Romy from YouTube. And yeah, welcome to the gang. There are a lot of other people who have filed in October of 2020, still did not receive the EAD in advance parole. In Texas Service Center though, it got a little bit better. They're starting adjudicating the applications, but definitely the amount of cases that are there right now and the amount of cases that got adjudicated, that means approved or made a decision, are very, very low. When we see the National Benefit Center, that's where things got much better. Nebraska is somewhere in between Texas and National Benefit Center. Definitely Texas Service Center is the worst that it could be.
Rao says, my spouse's H4 alien number and 485 receipt. I need to go to the end of the list, I guess. Let's see. Is it?
Anand has this question. Is EB5 discontinued? The regional centers of the EB5 is definitely discontinued right now, but the regular EB5s, that means that if you have your own business instead of regional service centers, that means that, let's say for example, you go and you start a new Chick-fil-A in some location. I'm just taking an example of it. And then you employ 10 people, definitely you're still eligible for the EB5. But it should be a business that you should be controlling it, not the regional center where you practically put your money, you don't do much activity in there. Those are discontinued right now.
Love to Learn says, do you think the new EB2 upgrade process will help utilize all the available GCs in EB2? I think that's what the intention is. Whether it actually happens will remain to be seen, because this is a completely new process. I don't think we've ever had a situation where they created a special filing address to do interfiles and to request transfer of the category from one to another. So how will they actually implement it? Can they get it done between now and September 30th? I don't have high hopes given the USCIS track record that we've seen over the past several years, but hopefully it will work out and they'll be able to utilize them all. They seem to be wanting to do that.
Applying I-140 with employer B in regular processing, can I still use employers A's I-140 to get the H-1B extended? Absolutely, yes, you can. If it's been approved for more than 180 days, employer A's, and the I-140 has not been withdrawn, you definitely can do extending H-1B with company B using the company A's I-140.
Srikanth wants to know, I have a passport renewal in the next 2 months. If I book an appointment for Dropbox with the old passport number, will I be able to update the new passport number on the already booked appointment? You may or may not be able to update it on your own, but you should be able to email that information to the consulate's public-facing web site and ask them to update it, or just bring the new passport to the Dropbox appointment.
Nayas Mohammed wants to travel to Cancun for 3 days. He doesn't have the passport stamped, passport visa stamped. I'm assuming that you have a valid I-94, you're maintaining a non-immigrant status. Yes, you definitely can travel to Cancun and come back because you're staying there for less than 30 days, even though your passport visa is expired, has expired. Anything else, Emily?
Let's see.
Anik has this question. 250 employees at the time of EB2, 100 employees at the time of EB3 downgrade, 50 employees now. Can I interfile to EB2? Absolutely no problem. Just because the company is losing the employees does not affect your interfiling EB2. It will not. Even though at the time when your EB2 got approved, 250 employees were there, right now in the 485J supplement, you list only 50 employees. It will not cause any problem whatsoever at all in adjudicating your 485 application.
Raj got his first H-1B back in 2018, but only used 6 months of it and moved to Canada, and wants to know, am I still eligible to use it for 5.5 years without going through the lottery? Yes, absolutely. No issues with that at all. Any company can file. It doesn't have to be the same company as before. They can file it at any time. They don't have to go through the lottery, and it doesn't have to be within 6 years of when you received that approval.
What can be expected when the Texas Service Center transferred to National Benefit Center? Should we get an RFE from NBC? You may be adjudicated by the NBC. You may be called for the interview at a local office. You may be expecting an RFE. Anything can happen once it's been transferred. We have seen, I don't know, Emily, I've seen a lot of the cases getting transferred here and there, sometimes from National Benefit Center to Texas, Texas to National Benefit Center, different. Any meaning in that?
No, and I love that they say, to speed up the processing in your case, we're transferring it to the Texas Service Center.
Really?
Yeah, that's where you want it to go. I can't figure out what they're doing. They're spending all this time transferring. Why don't they just approve it?
Yeah. It's strongly recommended for them to, instead of adjudicating all these EAD and advance parole, just approve the damn 485. You don't need to approve the EAD and advance parole. We have 4 EADs and advance parole pending from October of 2020. If you just approve the green card for those poor buggers, they don't need to get the EAD. They don't want EAD and advance parole. Just approve the green card. Definitely their path, their vision is not proper. Hopefully they get our voice and they get to read the letters that we are drafting for you. Please keep writing those letters to them so that you keep a pressure on the USCIS director and also DHS ombudsman.
Rao has an H-1B receipt date of July and the expiration date was October. This is July 2021. and the H-1B expired in October 2021 in regular processing, and wants to know, how long do I need to wait to follow up? Well, number one, only your employer or the attorney that filed the H-1B can follow up. I'm assuming it's considered way outside normal processing time, so they should have already been following up, or they should have upgraded to premium processing by now. Because if this is an extension, the 240-day auto extension of your employment authorization probably ended by now.
Any information on the premium processing of the H4 EADs? At this point of time, they haven't published it. Hopefully they will publish soon, but we don't know how long it's going to take at this point of time. No information on that. Screen is stuck. Daughter is having an EAD under the adjustment of status, and if we file the income tax returns using the social security number she got from the EAD, does it mean that we are married to the adjustment of status? No. The answer, if you use the EAD only for the driving license, only for the social security number though, definitely, and you use the social security to file the income tax returns, it is not considered to be marrying to the adjustment of status. If the person works on the EAD, then they will be considered to have been working, then the person would be married to the adjustment of status.
Kemlish wants to know, what's the benefit of filing concurrently? Does the officer start the I485 if the I-140 is not approved yet? If the I-140 does get approved, will the 485 be approved at the same time? I think the main benefit is the ability to get the EAD and AP earlier in the process, as well as the potential for AC-21 portability to kick in earlier. But as far as processing time, yeah, when the I-140 gets approved, the 485 does not get approved at the same time. That process continues on and can continue on for several months after, even when the final action date is current. And when filing concurrently, they tend to go to Texas, so that's not good.
Bharat is asking the question. He filed for H1, H4, and EAD. The H1 got approved. Now he is filing for an amendment of the H1B. What will happen to the H4 and EAD? The H4 and EAD will be approved, will not have any problem. Just because you filed an amendment, it won't create any problem for the H4 and EAD. We do not recommend in this current circumstances for you to reapply the H4 plus EAD. However, though, when people are moving from company A to company B, you got the company A's H1B approved, and H4 and EAD are still pending. When you're moving to company B, though, we strongly recommend to file the H4 plus EAD when you're moving from company A to company B, because sometimes these officers don't look into, there's another H1B that is approved, they look into company A's H1B has been withdrawn, they automatically deny the H4 plus EAD without issuing an RFE. That's when we recommend, when you're moving from company A to company B, definitely file EAD and H4 again.
All right, well, I think we're out of time for today. Thanks so much for joining us. As always, you can subscribe to our newsletter at rnlawgroup.com to get a weekly update of everything that's going on, or join on any of our daily conference calls.
Thank you guys for tuning in.